Please are you?
Ladies, my lord, I appear on behalf of the petitioners, the appellants and my learned friend, Mr. Passfield, on behalf of the company. Before getting to the substance, lady, I should like to deal with three housekeeping issues first. Initially, the kind of customary check that the court has all of the documents which are relevant, which include the core bundle, supplementary bundle, and the authorities bundle.
Yes, thank you. We have everything.
Yes. In respect of the core bundle, there was another version of that which was filed on the 4th of October. The only change to that, which I hope is the bundle that you do have, is that the kind of updated copy of His Honour Judge Cadwallader's judgment is in that. The way to tell whether that's the correct one is that in the index of the core bundle, it should read after tab 7, pages 51 to 64, not 51 to 63.
Yes.
Yes, I'm grateful. The next kind of housekeeping issue is in respect of the supplementary bundle. The document that appears at tab 12 was unfortunately missing a few pages from it. I thought the best way of remedying that was essentially to kind of reprint the document with the missing pages within that. And I have 3 copies of that to hand up. It is the skeleton argument that I produced in response to my learned friends at the hearing below.
Do we need it?
I think my learned friend would like to take it to some submissions in that, and I think some of the points may become relevant.
All right.
So I do have 3 copies of that that can simply kind of be inserted in. The missing pages are 51A and 51B, or page 2 and 3 of this document. And the final thing, my lady, is that it's a very kind of minor correction to paragraph 2 of my skeleton for this hearing, in that it's mentioned in paragraph 2 that the order arising from the judgment was yet to be drawn up and received, which was the position that I thought was the case at the time of writing. In fact, that order had been sent at some point, although not received by my instructing solicitors. But of course, that order does now appear in the bundle, which is at tab 8.
Yes, very well, we've got that.
Yeah, I'm grateful.
Now, you can assume that we've read the skeletons and indeed the papers, so if you can focus on the points that you feel you want to develop. Speaking for myself, I think a rather expansive view has been taken of how long this case will take. It seems to me it ought to be something that can easily be dealt with this morning. But if you disagree with that, then please let me know. Otherwise, please proceed accordingly.
Well, I'm grateful for that indication, my lady. I can then perhaps take a kind of more efficient procession through my submissions, and of course, subject to judicial intervention, we'll try my best to get it done within the course of the morning.
Very well.
I suppose, giving overview, my lady, this appeal raises 5 grounds, but essentially concerns 3 kind of broad issues. The first, which is engaged in kind of ground 1, but then kind of permeates through ground 4 and 5, is that if there was a requirement to take the petitioner's case at its highest at the preliminary hearing, and if so, what the factual and the legal implications of that was. So kind of ground 1 seeks to establish that, and then ground 4 and 5 essentially apply that. The second kind of broad issue is in respect of the Barclays payments and whether or not they constituted positive evidence of payment of debt or the ability to pay debts. And that engages grounds 2 and 3, but is almost kind of a standalone issue within the context of the other grounds. And the third is to do with the inference to be drawn from the fact of non-payment, if any. And that is kind of the central point that underlines ground 4 and 5. Now, the path that I had proposed to take through my submissions was to provide a kind of brief introduction of the facts, which I probably think is not necessary. If the court would think it helpful, then I propose to kind of have a brief run through the relevant legislation that was in existence at the time, and then kind of intertwine with that the kind of procedural history of the case. Whilst I am kind of cognizant of your comments, my lady, if that is something that the court would be assisted by, then I can do that.
Well, you take your own course.
Yes, I'm grateful. Now, the starting point is in the authorities bundle. Behind tab 3 at page 30 is the winding up petitions and coronavirus insolvency governance Act 2020 practice direction, which the key point that I want to look at paragraphs 4.1 and 4.2. Now, what they say at 4.1 is, provided the petition is not rejected for filing, it should be listed for a non-tenant pre-trial review. And then 4.2 says the purpose of the non-attendance PTR is to enable the court to give directions for a preliminary hearing in order for the court to determine whether it's likely to be able to make an order under section 1221F or 2215B of the 1986 Act having regard to the coronavirus test. So kind of procedurally what happened was District Judge Obadai conducted the non-attendance pre-trial review and made the order, which I don't need to take you to, but appears at page 1 of the supplementary bundle, essentially striking out the petition on the basis that it was based on a statutory demand which was defective or kind of barred by the legislation. Now, again, I don't need to kind of get into the details of this, but there was an application to set that aside, which District Judge Obadai granted, and then therefore listed it for a preliminary hearing in accordance with paragraph 4.2. Now, I think it's kind of spending a little bit of time on the preliminary hearing and what the court was going to determine, I think provides kind of colour to the remainder of the submissions. As stated at paragraph 4.2, the preliminary hearing was in order for the court to determine whether it's likely to be able to make an order under section 1221F, which, as the court is kind of probably aware, is just the ground that says a company may be wound up if it is unable to pay its debts. And you know that does appear at page 1 of the authorities bundle. And then the second part is having regard to the coronavirus test. Now the coronavirus test itself is defined in paragraph 1.3 of the practice direction, which is on page 29 in the authorities bundle.
And it's defined by reference to paragraph 5.3 of Schedule 10.
Yes, that's correct, my lady. So, kind of dealing with those in turn, as set out at 1.3, it says a position to wind up the registered company on the grounds specified in section 1231E, which is, of course, that the company is unable to pay its debts as they fall due. And the condition that has to be met is that which is set out in paragraph 5.3 of Schedule 10. So then paragraph 5.3 of Schedule 10 appears at page 9 of the authorities bundle.
Sorry, what page did you say?
Sorry, page 9 of the
Page
authorities.
9, thank
yeah,
you.
behind tab 2.
Yeah.
And that says that the court may wind a company up under 1221F on the grounds specified in 1231E only if the court is satisfied that the ground would apply, even if coronavirus had not had financial effect on the company. So for the purpose of kind of the preliminary hearing and kind of, with reference to paragraph 4.2 of the practice direction, kind of putting those two together, what the court was determining was whether the company would have been able to pay its debts as they fell due, that's the 1231E, even if coronavirus had not had a financial effect of the company. So that was the kind of coronavirus test. And then putting all of that together with the kind of paragraph 4.2 to determine kind of the composite test that was being applied, I think the easiest place to refer to is in my skeleton argument for the purpose of this hearing at paragraph 11. So in circumstances where there was no dispute that the company had in fact been affected by coronavirus, the test that the court was applying, or at least that the petitioners had to meet, was that it was likely that the court would be able to wind up the company, which is the kind of 4.2 practice direction part, on the basis that it was unable to pay its debts, that's the 1221F part, by finding that it was unable to pay its debts as they fell due, which is the 1231E part, even if coronavirus had not had a financial effect of the company, which is the kind of coronavirus test part. So it's a somewhat kind of convoluted kind of application of all of those various things, but I think that's an accurate statement of the test that the court had to apply. But notwithstanding the kind of convolution of that sentence, in my submission, essentially there was kind of one issue, which was about the inference of the inability to pay debts, because of course, if the court could have inferred that the company was unable to pay its debts before coronavirus, then the test would be met. Whereas if it couldn't make that inference for the period that applied before coronavirus, then the test would not be met. So hopefully that kind of provides the kind of legal landscape as to what the kind of courts below were considering. Now, in respect of District Judge Richmond's decision, I gather that the court would have already had a look at that. It's very brief and sits behind tab 11 at page 81 of the core bundle. Other than kind of pointing that out, I don't think much needs to be said about that at this juncture. But of course, given that this is a second appeal, and kind of part of the submissions which I make is that His Honour Judge Cadwallader essentially misconstrued District Judge Richmond's judgment, it will of course become important in due course. One thing to kind of say about this judgment as well is that I think my learned friend and I would probably kind of agree that it's perhaps, with respect, not the kind of best expressed by way of reasoning. So we're kind of left with a slightly kind of peculiar situation where, in my submission, the effect of His Honour Judge Cadwallader's judgment was to take District Judge Richmond's judgment, kind of apply his interpretation as to what it is that was being said, which is, with respect, a lot more kind of expansive than the words which are actually used, and then come to a kind of decision based on his own kind of interpretation of what was said, which kind of provides some further grounds for the appeal today. So that is the judgment. It's divided into three parts. The headings which are used are not the headings used by District Judge Richmond, but in fact ones that I did in my verbatim note. But the rest, I think, is agreed as a kind of verbatim note of the judgment itself.
Do you want us to look at that now?
Yeah. Perhaps very, very briefly.
Yes, just to sort of give us a bit of context.
Yes, yes. So this is that page 81 behind tab 11. So yes, the headings used are the only things which were not the actual words used by District Judge Richmond. It's essentially divided into three parts. The first kind of being introductory. I think the second sentence where he says, had you asked the company in 2019 whether they've been discharging the obligations, they would have said, of course. I think perhaps shows part of the thinking of District Judge Richmond in terms of the kind of the point that if one doesn't subjectively know that a kind of debt is due, how can it be deemed unable to pay it? But of course, he didn't express that much more than saying that there. The second...
I suppose one can understand. I mean, all he's saying there is, on their case, they were paying, so they had no reason to think that they weren't discharging their obligations. That's their case.
Yes, yes. And hopefully within the course of my submissions, I'll make clear that I completely accept that that is what their case was. But my point will be that in the kind of peculiar landscape that was a preliminary hearing, the assumptions that the court would have to make when it's going through the exercise of assuming that the relevant ground applies would have meant that the company's contentions in respect of the fact that it thought that it was paying the debt, that the Barclays account had been given to it upon instructions, all of those should take a back seat when comparing them with the company's case and the company's assertions. So perhaps that's a very short preview into kind of what I will say, but when I go through the ground, I think that point will become more clear. The second, or underneath the parameters of the hearing, that paragraph deals with the company's submission at that hearing that the court should have dealt with the substantive merits of the case and essentially struck the petition out because it was disputed substantially. Again, I think that...
I'm sorry, and do you accept that the petition is disputed on substantial grounds?
Yes, I accept that that is what the position of the company is. But, and if of course it were a final hearing, then that should take more weight. But, as hopefully will become clear, at least from my ground one, for the purpose of the preliminary hearing, the fact that it was disputed on substantial grounds should not have had the relevance that it in fact did by, or that His Honour Judge Cadwallader paid to it.
Well, if it's disputed on substantial grounds, it's going to come off the rails on your view of things at the next hearing, isn't it?
Well, so in terms of what I accept that the company said that it was disputed on substantial grounds. But the fact that somebody does dispute it on substantial grounds doesn't mean that the court will necessarily uphold those substantial grounds and that it's a kind of bona fide good faith dispute.
Sorry, as I understand it, Mr. Ayub, I think what you're saying is you accept that the company's case is that it's disputed on substantial grounds. You don't agree that the grounds on which it's disputed are substantial.
Yes, yes.
That's what you're saying.
Yes, much more eloquent way of phrasing it than I. My lord.
But your point is, for your ground one, that it's all irrelevant anyhow, because you wouldn't be considering that at a preliminary hearing.
Yes, yes, of course. And I'll turn to ground one in just a moment, but just to finish the kind of brief look at District Judge Richmond's judgment. That paragraph under parameters in the hearing, I think, will become more relevant to my learned friend submission on what the court should have been considering, or whether the court should have struck the petition out on the basis that it was disputed. And then the remainder underneath the heading coronavirus test is, I think, what District Judge Richmond was actually considering for the purpose of the test that I've just taken the court to through the legislation. And it might be that you want to take a moment to look at that, but I will go through the various and relevant bits as I go through the grounds. So, starting with ground one, my lady. it probably helps to turn to paragraph 41 of the judgment, which is at page 61 of the core bundle behind tab 7. Now, this paragraph is divided into 3 parts. The first 8 lines or so deal with the law. The next sentence after that, petitioners did not appear to dispute that the company believed it was making payments to the Barclays account and instructions. Then I suppose sets out the reasoning, i.e. what His Honour Judge Cadwallader was taking into account in coming to his conclusion, which is then in the next sentence. The fact that the alleged debt had accrued prior to the pandemic was not evident the company was unable to pay its debt as they fell due before the pandemic. Now, this ground takes issue with the prior sentence, and in particular, the first part of that the petitioners did not appear to dispute the company believed it was making payments to the Barclays account on instructions. And the ground itself is replicated in my skeleton argument at page 5. In italics. So just working through that, the first sentence kind of reproduces, or rather, it says the litigants found that the fact the alleged debt had accrued prior to the pandemic was not evidence that the company was unable to pay its debts as they fell due before the pandemic. And then what he relied on was the fact that the petitioners did not appear to dispute the company believed it was making payments to the Barclays account on instructions. Now, in my submission, that was wrong, both in fact and kind of alternatively in law, because although the petitioners didn't dispute that the company believed it was making payments to the Barclays account per se, what it did dispute was that those instructions were given at all. And in my submission, that has 2 implications. Because where there's a dispute that instructions were given, then number 1, that is a dispute that there was any basis for the company to make payments to the Barclays account at all.
As I understand it, though, Mr. Ayu, that statement, it is disputed that the instructions were given at all.
Yes.
From my mind, logically, that doesn't contradict a fact that the company believed it was making payments on instructions. You're not contradicting that fact. You're saying there are other facts, but you're not saying it's wrong that the company believed it was making payments on instructions.
Yes, that is correct, my lord. And I think the second implication, which perhaps deal with that point, is that I say that it amounts to a dispute that there was any basis whatsoever for the company to believe that it was correct to make payments into that account. So, yes, it doesn't contradict the fact that that is what the company says it believed. But it says that there's absolutely no basis for the company to have had that belief that it was correct to do so.
That sounds like you're actually really trying to say that actually you don't really agree that the company believed that, but you haven't disputed that the company believed that.
My lord, I suppose it's difficult for the petitioners to kind of subjectively get in the mind of what it is that the company thought or didn't think at the relevant time. So putting a submission kind of at the level of the company did not have that belief is perhaps a difficult one to make and wasn't made for that reason. But in my submission, it's difficult to kind of separate the one from the other, in that if the company's belief was that it was discharging the debt because the company believed that the Barclays account was given to it by the company, by the petitioners, then if you're disputing that those instructions were given, then kind of by implication you are disputing that there's kind of any basis for the company to have that belief. I think that's the kind of height of the point in, as I can put it, my lord.
So it's basically whatever they say they believed, they couldn't have believed it on any reasonable grounds.
Yes, that is the point, my lady.
Or you're not disputing that they may believe it because you can't get inside their minds, but you'd say it was irrational given that there were no instructions.
Yes, those are the points. And the next kind of point in italics is, in those circumstances, the court at the preliminary hearing, where the substantive petition is not an issue, and of course I'll come to that, should have taken the petitioner's case at its highest and then assumed that no instructions were given. And I suppose to kind of tack on to that, the point that we've just canvassed, should have also assumed that there was no basis for the company to have a belief that it was correct to make the payments to the Barclays account. And this submission is actually something that I largely agree with the reasoning of His Honour Judge Cadwallader. As I've set out from paragraph 15 of my skeleton, perhaps it will assist the court to turn to paragraphs 37 and 38 of the judgment, which is at page 60 of the core bundle. And again, I think it might assist the court for me to kind of bring out the relevant legislation that the judge was referring to in order to demonstrate why I say that he was right in what he said here. So what the learned judge says is he starts in paragraph 37 by referring to the CIGA requiring the court to make a determination whether it's likely the court will be able to make an order under 1221F before any notice, publication, advertisement of the petition. Now, this is the provision which is at page 23 of the authorities bundle. And it's, in summary, something that prevents the advertisement or publication of the petition until the court has considered the coronavirus test. Or at least I say that is what it is. So it is, yes, rule 7.51 of the insolvency rules has effect if it also requires the petition. No, sorry, I'm looking at the wrong page there. Sorry, 19.2. I appreciate my learned friend pointing that out. Any provision of the insolvency rules which requires or permits notice, publication, advertisement of the petition does not apply until such a time as the court has made a determination in relation to the question whether it is likely the court will be able to make an order under section 1221F. So, of course, this is one of the many reasons why then the court has the preliminary hearing in order to determine that question. Now, His Honour Judge Cadwallader then says in paragraph 37 that within this context, likely means given the restrictions on winding up petitions for which Schedule 10 provides. And in my submission, that is entirely correct, because it makes perfect sense, given that the whole purpose behind that part of the Act was to provide restrictions which were referable to coronavirus. And of course, that provision is found within Schedule 10. So the restrictions in question for the present context were those that I've already taken the court to, which are set out in paragraph 5.3 of Schedule 10. And His Honour Judge Cadwallader starts paragraph 38 by referring to that. The restrictions in question are those for which paragraph 5 of that schedule provides, which then kind of brings us back to the coronavirus test in 5.3 that I've already taken the court to. Now, in his interpretation, and I kind of simply repeat and I suppose what it colloquially jump on the back of this analysis, the sentence that starts as a matter of construction, the words even if direct the court to the financial effect of coronavirus, not to the applicability of the relevant ground. And it, I suppose, may assist the court to just kind of very quickly flick back to 5.3, which is at page 9 of the bundle. Just to see the wording. Sorry, page 9 of the authorities bundle. So it's purely a construction point that the words even if direct the court to the coronavirus test, not the applicability of the relevant ground. And in my submission, that is the reading that should be applied to this part. And if that is correct, then again, I submit that what His Honour Judge Cadwallader said was entirely proper, where he continued at paragraph 38 that the court is to assume that the relevant ground applies, rather than determining whether it is likely to apply or not, when considering whether, on the assumption that it does apply, it would have applied even without the effect of coronavirus. And then he said that may involve some mental gymnastics in at least some cases. And he kind of goes on to talk about the court's ability as a matter of case management to consider whether it should be struck out in other grounds. We can perhaps deal with that last sentence in due course, because I suppose my submission will be that, you know, if the reason you're striking out the ground on case management decisions, on case management discretion is, for example, a procedural one, as District Judge Obadiah did in this case, that it was based on a statutory amendment which was defective, then that is kind of entirely proper and consistent. Whereas if the kind of striking out on other grounds equals a substantive kind of analysis of the merits, then in my submission that is kind of contradicted by what has just come before in paragraph 38, which is that the court is to assume that the ground applies, rather than determining whether it's likely to apply or not. When considering on the assumption that it does, it would have applied even without the effect of coronavirus. So, in other words, I say that His Honour Judge Cadwallader was entirely correct in his analysis for at least those kind of first sentences of paragraph 38. And at paragraph 39, where he says, it is unlikely that Parliament would have intended to raise a threshold for petitions on grounds unrelated to coronavirus. That would have required clear words. I think the point there, which is again a correct point, is that if the court at the preliminary hearing was essentially substantively determining the case, then, you know, even if, say, coronavirus ends up not being a stumbling block to a petitioner at that hearing, because, for example, the court finds that coronavirus had no effect on the company, then a petitioner nevertheless is kind of forced to satisfy a pre-final hearing test based on the likelihood of a ground applying. And the purpose of the kind of coronavirus legislation wasn't to kind of create this kind of new juncture before the hearing, the final hearing of the petition, where the petitioners have to convince the court that the ground itself is likely to apply. The focus was on the applicability of the coronavirus test. So I appreciate that I spent some time on that, but I think it's important for me to say why I think His Honour Judge Cadwallader was correct.
But what do you say about his conclusion that therefore the court must make an assumption that the ground is met? Where in the wording do you put that? Where do you find the assumption?
So there is no clear place at which the statute or the practice direction sets out the assumptions that the court is to make, and that is kind of perhaps how we find ourselves here before the learned court arguing that point. I suppose my point is that for the reasons which he has set out in paragraph 38, it's correct to apply that reading to the statute, and I suppose to to add to that, if we're trying to take a step back and kind of consider, what the purpose of the preliminary hearing was, you have a hearing that takes place at a point that is before the kind of final hearing of the petition, in that if it passes the coronavirus test, then we kind of get to the final hearing of the petition. So just on a kind of very kind of rudimentary analysis, it makes perfect sense for the preliminary hearing to have its focus on the coronavirus test, assuming that the relevant ground applies. And then the dispute about whether the relevant ground does apply or not, i.e. whether, the debt is kind of disputed on substantial grounds, etc. That can then happen at the final hearing of the petition. So in my submission, then it kind of, although the assumption itself is not set out in the legislation, it completely makes sense when within the context of the restrictions that existed at the time.
Why do you have to make any assumption at all?
Because in my submission, my lord, if you don't make that assumption, then you are treating the preliminary hearing as if it is the kind of determination of the final hearing itself. In that if the court isn't assuming the ground applies, but saying you have to prove to the satisfaction of the court that the ground does apply, well then if the ground does apply, then that essentially will determine the point.
No, it's not as simple as that, though. Aren't the facts of this case perhaps evidence of why one shouldn't take a simplistic approach and just assume things? Because the difficulty in this case is to do with the interaction between the ground that you're relying on and the coronavirus.
Yes.
Because what this is all about is that until coronavirus, your client hadn't complained.
Yes.
And that's why this belief is all part of this story, because the belief existed until the coronavirus took place.
Yes.
Pandemic. So there's a relationship between the grounds that you're relying on and the coronavirus pandemic, which is inherent in the case. So by trying to make assumptions about it, you then start getting in a tangle, at least as it seems to me, between the difference between the ground you're relying on and the effects of the coronavirus pandemic. Because in fact the two are intimately intertwined, because of the fact that your client didn't do anything until the coronavirus pandemic started.
Yes, I see the point that you make, my lord. But if we move away from the facts of this case for a second and just think about what a court should be determining at the preliminary hearing, either it does have to assume the relevant ground applies, or it doesn't. And if it doesn't assume that the relevant ground applies, then of course, all the points that you may kind of flow from that. But if the rule is that it has to assume that the relevant ground applies, then the kind of factual basis that underpins that relevant ground has to also be applied consistently. And in my submission, that is, at least for the purposes of the preliminary hearing, that affects, I suppose, the coronavirus test, in that, and perhaps this will kind of be made clear in my next submission, which is the kind of final point in italics. But I suppose kind of going back to how I initially started answering the question, I believe that you kind of had to make a decision as to whether or not the ground is assumed to apply or it isn't. And if it is assumed to apply, then one has to examine the implications that come from that. And the kind of its interaction with the coronavirus test will flow accordingly. Okay. So the final point is that had it taken the petition's case at its highest, then the fact that the company was making payments to a Barclays account would not have been relevant, as neither would the point on belief. Because kind of circling back to my point in answer to Lady Justice Thirlwall's question, without any kind of instruction to pay, then obviously the fact of payment to the Barclays account becomes a red herring, because it's just kind of payment to kind of a a random account with kind of no factual context that the court has. And secondly, I say that the court should have assumed going forward that there was no ground and also no reasonable ground for the company to believe that it was making payment to the Barclays account upon instruction. And of course, the extent to which that then is kind of aired out at the final hearing can happen, but for the purpose of the preliminary hearing, that is what I say the court should have done. And I think finally on this point, all I say is that on the company's own case, I think its belief was kind of inextricably tied to its assertion that there had been an instruction. So the two kind of go hand in hand, I suppose, to your point, my lord. And just so the court has the references, and I don't propose to take the court to kind of the evidence in any more detail than this, but in the supplementary bundle, behind tab 16, is page 87, which is the first witness statement, I think, of Mark Valentine. And what he says at paragraph 8 is, in around 2013, instruction was given for payments due to the petitioners in respect of Rosen Street to be sent to a different bank account. And by that, he means the Barclays bank account. So the company's case was that these instructions were given for us to send the money to that account. And then at page 89, just a couple of pages after, at paragraph 23, the third sentence, where it says those investigations have not been helped by the matters detailed at paragraph 16, so it's talking about the difficulty of obtaining the relevant evidence. But it says it's the company's genuine belief that the account to which payments had been made were supplied by the petitioners to the company, which I think then goes to the point that if you take away the kind of any credibility in the assertion that the Barclays account was provided by the petitioners, so too goes any basis for having the genuine belief that the accounts to which payments have been made were supplied by the petitioners to the company. So I suppose this is kind of a foundational point, because it's upon those kind of assumptions that the points from ground 4 and 5 then rest. So moving on to ground 2, and I suppose I could probably spend less time on grounds 2 and 3 as they're kind of fairly discrete points. As stated when we were looking at the judgment of District Judge Richmond, one of the points which was being made on appeal was that District Judge Richmond was essentially wrong to have treated the payment of money into the Barclays account as positive evidence that there was payment of debts and the ability to pay debts as they fell due, which was, in my submission, a very, very straightforward point. And if His Honour Judge Cadwallader had properly interpreted that point, should have found that District Judge Richmond came to the wrong decision. We can very quickly look back at District Judge Richmond's judgment, which is at page 81 behind tab 11. The relevant sentence is here, being under the paragraph coronavirus test, the penultimate paragraph, the first sentence that the fact the company seems to have been paying rent into the Barclays account suggests they were able to pay debts as they fell due, up until including the commencement of the coronavirus pandemic. So I say that that's District Judge Richmond saying that the payment of the rent into the Barclays account equals positive evidence that the company was able to pay its debts as they fell due. And then the last sentence, which is before the pandemic, they were paying their debts, albeit paying it into the Barclays bank account. So that's kind of clear as day in my submission, that what he's saying is that before the pandemic, this was evidence of the payment of their debts. And I say that, well, that was wrong, because it's basically the case that if a party is paying money into an account which, or if party A owes party B a contractual obligation to pay monies and pays that money into the account of party C, and party B didn't give A the instruction to pay it into the account, then that simply can't be treated as payment of debts as they fell due. Positive evidence of that. And
why isn't it positive evidence, if they had the belief, which you don't dispute, that they were paying the debts they believed they had when they fell due?
For the court to find that there's positive evidence of a company paying its debts, I think the key focus is on the term debts. It has to be on the payment of one's debts. And one can only pay a debt if you're discharging the obligation that is owed to the party. So I just say, as a matter of logic, irrespective of someone's belief, if they are paying money into an account but that doesn't have the effect of discharging the debt, one can't treat that as positive evidence of the discharging of the debt or of the payment of the debt.
But you're talking about, the point is that it's evidence of an ability.
Yes, so the ability point is...
The fact that you're paying the debts you believe are due is surely evidence that you have the ability to pay the debts you believe are due.
Yes, so the ability point is slightly separate. My first point is kind of a technical point on payment of debts. The second point in regards to ability is that in circumstances where, in my submission, there is basically no evidence whatsoever that there was any instruction given to pay monies into the Barclays account. All you have is the transference of money from one place to another. Yes, I accept that the company says it was doing that in order to attempt to discharge its debt, but in circumstances where there's absolutely no evidence of the instruction, then the court, all the court really has, kind of objectively, is the payment of money from one place to another, with kind of no factual context that it can kind of pin its logic on to suggest that that is actually the ability to pay debts. And I think this kind of goes, again, well, I suppose partly goes to some of the assumptions which are kind of being made in ground one, but even if we don't necessarily make those assumptions, just very simply speaking, you have one party saying you owe me money, another party saying we've put that money in this account, and there's a paucity of evidence as to exactly why the money was put into that account.
Your example is misleading, because when you say you owe me money, the point is your client never said you owe me money that you haven't given me. Of course they said at the very beginning you need to pay me. The company did.
Yes, yes.
Your client never said no until the coronavirus pandemic.
Yes, I suppose that's kind of lazy wording in the example that I gave. I think the proper example should be in circumstances where there is an obligation to discharge a debt, or sorry, there is an obligation to make a payment, and then the company is saying, or rather, the company is asserting we discharged that obligation, or we thought we were, by paying it into this account, but there's a paucity of evidence as to why it was paying it into that account at all. In my submission, that those factors mean that the court doesn't have enough to say that that's an ability to discharge debts. It's an ability to move money from one place to another, but that simply has no context, because there's a paucity of evidence as to why it was doing that. But again, I think that's the strongest way that I can put the point, my lord. In terms of ground 3, this is perhaps very similar to ground 2, in that what it says is that Judge Cadwallader then provide his own characterisation of District Judge Richmond's point, and the point of this ground is to say that, well, even his own Judge Cadwallader's characterisation is itself wrong. Now, the points are, when I kind of come to the meat of it, very similar to that which was made in respect to ground 2, but just kind of dwelling on this ground for a second. What it says is that even if District Judge Richmond had expressed his finding in the manner suggested by his own Judge Cadwallader, that payment into the Barclays account was evidence that the company was not unable to pay its debts as they fell due, up until and including the commencement of the coronavirus pandemic, such a finding would still be wrong in law. Now, if we very quickly turn to his Honour Judge Cadwallader's judgment, which is behind tab 7, at page 61 and 62. At the bottom of page 61, and what he says is it wrong to say the district should consider the company's pre-pandemic payment of rental money to the Barclays account to be evidence of its payments of its debts, and all payments of its debts if they fell due. This is, on the contrary, he considered as evidence that it was not unable to pay its debts as they fell due, up to and including the commencement of the coronavirus pandemic. So what he's saying, he's kind of applying his own gloss to the wording of District Judge Richmond, and he's saying he didn't consider it as positive evidence that it was able to pay its debts as they fell due, but he considered it as positive evidence that it was not unable to pay its debts as they fell due. And in my submission, as a point of construction, I say that there is kind of very little between the two. If he's considering as positive evidence that the company is not unable to pay its debts as they fell due, then that is essentially positive evidence that a company is able to pay its debts as they fell due. So as a matter of construction, I say that there's nothing between the two. And I suppose it's also important to know that I say that His Honour Judge Cadwallader kind of tacitly approved District Judge Richmond's finding, because within the context where he's kind of being asked to essentially disapprove it, rather than doing that, he kind of gave his own characterisation of it and didn't kind of expressly say that he disagreed with the sentiment that lay behind it. He kind of recharacterised it, in my submission, almost with approval. And I say that that is wrong, basically because of the same reasons that ground 2 is wrong. The same kind of logic follows, so it probably doesn't really assist for me to kind of go through that again. Now, moving on to ground 4, which is to do the inference point. And this starts at paragraph 42 of the judgment again, which is where we've just been looking at pages 61 and 62. But it's to do with the kind of second part of the paragraph that we've not looked at yet. The first part of the paragraph, in my submission, the sentences that we looked at concentrate on whether there was positive evidence that the company was able to pay its debts as they fell due. Now, that is quite separate from the next part, which is dealing with whether or not, from the kind of fact of non-payment, there can be an inference of inability to payment. Inability of to pay debts as they fell due. The first part, positive evidence. Second part, inference from the lack of payment. What he says is, and I'll highlight 2 points in particular when considering this. No debtor fails to discharge debts when they fall due may found an inference that the debtor is unable to pay its debts as they fall due, but where, as here, there is, point 1, a dispute about whether the debts have been discharged, in point 2, if they have not, the natural inference that it was only the result of a mistake, it's impossible to infer from the fail to discharge debts an inability at the time the payments were made to do so. And those 2 points which I've highlighted then form the grounds of the appeal. So as indicated at paragraph 9 of my, page 9 of my skeleton, under ground 4, the kind of 2 points I've just picked out in the judgment then represent, A and B in the paragraph in italics. So I say, I suppose in respect of A,
I'm sorry, where do we find A? A is in your...
Sorry, I should have given you more time, my lady. This is at page 9 of my skeleton.
Yes.
Underneath ground 4. So...
Oh, I'm sorry, we're talking about the dashes. Yeah, I was looking for an A. It's okay.
Right, yeah, so in the...
It's okay.
Just for the avoidance of doubt, so in the body of the paragraph underneath ground 4, I've split that into 2. I said, following payment to the Barclays account A, company contending the fact that debt has been discharged.
Just third line of ground 4.
Third line, that is the A I'm referring to, yes.
Thank you.
Now, as you have probably gathered, this kind of flows on from the point I was making in respect of point 1, which is that if I'm correct about the assumptions that the court should have been making about the relevant ground applying, and I'm correct in respect of ground 1, then it should have been proceeding, or rather the court should have been proceeding on the assumption that there were no instructions to pay rent into the Barclays account, because it has to be one or the other. If there were instructions to pay rent into the Barclays account, then the ground could not apply, because the debts would have been paid into an account that was nominated by the petitioners. So if there's going to be an assumption the relevant ground applies, then one has to assume that there were no instructions to pay rent into that account. And the kind of 2 implications that I state in ground 1, which follow, are that the factual contention that the company had in fact been discharging the debt, that then has to go or to be disregarded. And secondly, that the company's belief that it was discharging the debt also has to be put to one side for the same reason, in that there's essentially no ground or no reasonable ground or no rational ground for having that belief. So, to the extent that the learned judge was relying on that, I'd say that he was wrong to rely on that.
So it flows directly, in fact, from ground 1, because
Yes.
Your case should have been taken at its highest. If you take your case at its highest,
Yes.
then little a, their contention is irrelevant.
Yes.
And little b, the fact that they think there was a mistake is also irrelevant.
Yes. Yes. That is.
Because their mistake or their belief is irrelevant.
Yes. I say that the 2 have to follow, and I suppose in respect to the mistake point, I should very quickly refer you to paragraph 24 of my skeleton, the last dash underneath it, which is on page 10. I'll start the last sentence of that, which is, the court could not make a natural inference that the payments were a mistake, which is basically the point that I've just canvassed before my lady. You can kind of view this 2 ways. I think, one, that there was essentially kind of no basis for any kind of belief that the monies were being paid in on instruction. But I said the court should have made no inference as to the reasons behind non-payment, because the reasons behind non-payment lay in the factual assertion that the account had been provided to the company by the petitioners. That's what the company submitted as the reasons behind the fact that it didn't actually discharge the debt. Saying, well, you told us to put money into this account, and saying if that fact goes, then the court really doesn't have anything before it that it can kind of make any inference as to the reason behind non-payment. So again, it's perhaps the mental gymnastics that Judge Cadwallader talked about, but that is That is what my point is. And if the court has that point, then I think I can kind of move on to my ground 5. And this is it deals with the kind of inference of the inability to pay debts and kind of what to make of the fact that the company wasn't actually asked for the money before coronavirus. So perhaps this goes some way to addressing one of the points made kind of in opening by my lord. Essentially, ground 5 kind of emphasises that the focus here on the facts of this case should have been on the kind of contractual obligation that existed to pay the sum. I think the way that the ground is expressed perhaps requires a little bit more elaboration. What the ground says is the learned judge found that District Judge Richmond did not conflate unable to pay its debts as they fell due with unable to pay its debts when demanded. He said that because the petitioners did not tell the company until much later that the money was going to the wrong account, the supposed failure to pay when the sums fell due does not go to the question of inability to pay. Then I say that the judge erred in law because if the contractual obligation exists, then the ignorance of one failure should be kind of irrelevant to that contractual obligation. Perhaps that's a kind of slightly strong way of putting it on first blush. My submission here is not that every single time that there's a failure to pay a sum arising pursuant to a contract, there should be an automatic inference of inability to pay debts. I don't think I could kind of persuade the court of that. But my submission is that on the facts of this case, where the court is kind of going through this kind of fiction of making the assumptions that I say it should make by virtue of ground 1, then it could kind of attach no weight to the company's reasons for non-payment and should have made no inference as to the reasons for non-payment and found no grounds for the belief that it was kind of discharging the debt. So all it was left with in those contexts is the kind of contractual obligation to pay and the failures to pay. And within that context, I say that it should have inferred kind of inability to pay arising from the mere fact of non-payment.
And that arises because of the assumption again?
Yes. I think the assumption is key. But obviously the assumption is kind of foundational to everything else that flows. And I suppose, just by way of kind of further analysis, I say that what the court had before it was kind of four elements. One being knowledge, i.e., I'd say the company's knowledge of the sums which it should have paid. 2, opportunity to pay those sums. 3, a failure to pay those sums. And 4, no adequate reasons for non-payment, which again I say flows from the assumptions. And just adding a kind of little bit of colour to that. The first element, knowledge. I say that the kind of contractual obligation here to kind of make the payment is the basis for kind of imputing a knowledge about the need to pay. I.e., upon the receipt of monies from the various tenants, the company knew that it had to kind of account and then whatever it received less expenses pay over. So there's kind of there's a knowledge about the need to pay that sum. Secondly, in terms of opportunity, there was the opportunity to pay comes at the point that the kind of money should have been paid over. That's a different question from the kind of opportunity within the context of, I think, my law's point, which is that asking the company again for the facts for the payment of the debt. But I say that there was an opportunity to pay the money, so this isn't, as I'll perhaps come to, like in some of the cases where there's a debt that arises by virtue of a kind of unilateral accounting creation, where there's no kind of opportunity at any point to actually pay that money that has has arisen. Here there was an opportunity. And thirdly, the failure, which comes after the opportunity isn't taken. And then fourthly, the reasons for non-payment were kind of, prima facie examined, and if one takes the assumptions, which I say are key, then those reasons for non-payment, or rather, there were no good reasons and no well-founded reasons for non-payment, if you take away the factual assertion that the company was told by the petitioners. So I think that that deals with that point. I probably don't really need to go into the kind of notification point at this juncture. It might be better for me to do that in response to what my learned friend says. But unless the court has any further questions, I think those are my submissions.
No, thank you very much indeed, Mr. Busfield.
I want to begin with what's probably a trite proposition, which is that the order that's under appeal is the order made by District Judge Richmond at preliminary hearing, simply dismissing the petition. The District Judge's reason for dismissing the petition was that the appellants had failed to demonstrate that the condition in paragraph 5, subparagraph 3 of Schedule 10 to the Corporate Insolvency and Governance Act 2020 was satisfied. That's to say, the appellants failed to satisfy the court that the company would have been unable to pay the petition debt even if coronavirus had not had a financial effect on it. That decision was upheld by Judge Cadwallader on the first appeal, and in my submissions, for the reasons which I will develop, the judges below were correct to reach that conclusion. But as set out in my respondent's notice, there was an additional and arguably more compelling reason why the district judge was right to dismiss the petition, which is that the petition debt is clearly disputed on substantial grounds. My learned friend has taken you to the district judge's judgment, which is at page 80 of the core bundle. And if I can just invite your ladyship and lordship to turn that up momentarily. It can be seen, in essence, that the district judge decided that the preliminary hearing was the inappropriate forum for dealing with questions of substantial dispute. And then in his judgment on appeal, on page 63 of the core bundle, behind tab 7, in paragraph 50 of his judgment, Judge Cadwallader indicated he would not have been prepared to uphold the dismissal of the petition on this ground because the decision not to consider that argument was a case management decision for the district judge. As I've indicated in my skeleton, I have effectively 3 lines of argument in this regard. So firstly, it's my primary case is that by virtue of the relevant legislative provisions to which I'll take the court in a moment, the court was required to consider the substantial dispute before turning to consider the coronavirus test, if at all. And that is set out in paragraphs 28 to 30 of my skeleton. My secondary case...
You want us to look at that? Sorry, you're summarising it.
I will take you to it in due course,
right.
lady, unless you want me to take you to it now. Yeah. My secondary case is that even if it was not necessary for the district judge to consider that argument, he nevertheless should have done so because in its evidence in opposition to the petition, the company made it clear that it intended to seek the dismissal of the petition on those grounds, and the court heard full argument from both parties on the issue. And this is then set out in paragraph 34 of my skeleton. Again, I'll go to the argument in a moment. And then thirdly, my tertiary case is that if it is necessary to do so, this court, in the exercise of its case management powers, can and should dismiss the petition on the alternative basis that the petition debt is disputed on substantial grounds, so as to avoid the unnecessary further expense and cost of an application to restrain presentation of the petition and consequent and further hearing. Now, it was unnecessary for the judge below to consider that tertiary argument, because as he indicated in paragraph 51 of his judgment on page 64 of the bundle,
having concluded that Judge Richmond was correct on his analysis of the coronavirus test, the decision to dismiss the petition was upheld on the primary ground. So he didn't opine either way as to whether he would have been prepared in the exercise of his case management powers to dismiss the petition on that alternative ground. The final point I wanted to make by way of prefatory remarks is that although, as my learned friend has indicated, the appellants have advanced 5 grounds of appeal, really in my submissions there are 5 reasons for saying that the judges below got the coronavirus test wrong. What I say really is there's one ground of appeal, one issue before this court on terms of coronavirus test, which is whether or not the courts below were right to conclude that the appellants had failed to discharge the burden of demonstrating that the company would have been unable to pay the petition debt even if coronavirus had not had a financial effect on it. And I accept that that question is essentially a value judgment. It doesn't involve the exercise of discretion. So this court is as well placed as the courts below to determine that question. Having said that by way of introductory remarks, what I propose to do is to look briefly at the legal framework set out first in the Insolvency Act, then in the 2020 Corporate Insolvency and Governance Act, and then the Practice Direction, as considered by Judge Cadwallader in paragraphs 19 through 40 of his judgment, and are set out in paragraphs 21 to 27 of my skeleton. Then I'll address why I say that it's clear that the petition debt is disputed on substantial grounds. I will then address why the courts below were correct to conclude that the coronavirus test was not met. And finally, to the extent necessary, I will just consider some of my learned friends' individual grounds, although as I've indicated, they're not so much grounds as arguments in support of what I say is his overarching ground. So if I can turn into the legal framework, and I appreciate there's a great risk in doing this of teaching the court to suck eggs, so to the extent that I'm dealing with what are trying to easily understood propositions, then please do move me on. But I'd like to begin by looking at section 122 of the Insolvency Act, which appears on the first page of the authorities bundle. Section 122, as the court will know, sets out the grounds upon which the court can make a winding up order. And for present purposes, the court is concerned with the ground in subsection 1F, which is that the company is unable to pay its debts. Section 123 on page 3 of the authorities bundle then sets out the grounds on which a company is deemed unable to pay its debts. And for present purposes, the court is concerned with subsection 1E, which is that it's proved to the satisfaction of the court that the company is unable to pay its debts as they fall due. As Lord Walker observed in the Eurocell case, which is behind tab 8 of the authorities bundle, I didn't take you to the relevant passage, but it's for your pen, paragraph 25. Unlike subsection 1A and B, subsection E is not what would usually be described as a deeming provision. It does not treat proof of a single specific default by a company as conclusive of the general issue of its inability to pay its debts. Instead, it requires the petitioner to demonstrate that the company is unable to pay debts as they fall due. Now, as the court will know, in an ordinary case, a petitioner will overcome this evidential burden by demonstrating that the company owes the petitioner an undisputed debt of £750 or more, which is not being paid. But as I'll now demonstrate by reference to the case law, the mere fact that a company has failed to pay an undisputed debt does not give rise to an irrebuttable presumption or an irresistible inference of insolvency. And I make that submission good now by reference to 4 cases, the first of which is the decision behind tab 5 of the authorities bundle, is the decision of this court in the case of Retailers Industrial Flooring Limited. This was a petition which was presented in respect of an unpaid invoice. The company defended the petition on the basis that the invoice had not yet fallen due for payment. The court rejected that argument, so was dealing with a case of non-payment of an undisputed debt. At first instance, Mr. Justice Scott refused to make a winding up order, and the relevant part of his judgment is the highlighted passage on page 40 and 41 of the authorities bundle, pages 46 and 47 of the law report. And it begins, in my judgment, at the very bottom of the page, final paragraph. So he said, in my judgment, something more must be proved than simply that the company has not paid a debt. In some cases, the circumstances surrounding the non-payment may justify the inference that the debtor is unable to pay its debts as they fall due. And he then gives the example of a series of dishonest checks. And then goes on to say, but in the present case, a reason for non-payment has been put forward. The reason may not be a very good one, but unless it's not being put forward honestly, I do not see why an inference of inability to pay should be drawn from the fact of non-payment. And he then went on to observe that had the petitioner availed themselves of the ability to serve a statutory demand, these issues wouldn't have arisen. The petitioner appealed that decision to this court, and the leading judgment was given by Lord Justice Dillon, and one can find the relevant part of his judgment over on page 43 of the authorities bundle. So, starting at letter F, he quoted the passage from Mr. Justice Scott, which I've just read out. Then, in the final paragraph on page 43, he explains why, as a matter of practice, a petitioner ordinarily won't serve a statutory demand, which is, in essence, it gives the company a further 3 weeks in which to become more insolvent. And then the key passage is that which is highlighted on page 50. Lord Justice Dillon said that the short answer to Mr. Justice Scott's view was twofold, and that they run together. So the first limb is that if a debt is due and an invoice sent and the debt is not disputed, then the failure of the debtor company to pay is itself evidence of inability to pay. And I put particular stress on the words and an invoice sent, for reasons I'll come on to in a moment. And he then set out passages from the well-known judgment in the Cornhill insurance case, which was a case in which on any view, solvent company had failed to pay an admitted debt without any reason, after having been asked for it. And in those circumstances, Mr. Justice Harman, perhaps counterintuitively, determined he could properly draw the inference that was because of inability to pay in the absence of any other explanation. And then Lord Justice Dillon then said at letter D, the second point, and again I place particular emphasis on this, is that the reason for non-payment has to be substantial. It's not enough if a thoroughly bad reason is put forward honestly. The second authority I wanted to take your ladyships and lordship to is the decision of Mr. Justice Chadwick in the rear company case, which is behind tab 6 of the authorities bundle. And there are two passages I wanted to draw the court's attention to in this, and the first appears on page 57 of the authorities bundle, at letters D to E.
Page 57?
Yes. It's the highlighted passage that starts just above letter D. Where the judge said there's no doubt that the terms of section 1231E of the Act of 86 enable the court to reach the conclusion that the company is unable to pay its debts as they fall due on any evidence which satisfies it of that fact, not necessary for there to be a statutory demand, nor in exceptional circumstances is it necessary for there to be a demand at all. And this is the key bit. But it appears to me the statutory provision which deems inability to pay debts on failure to meet a statutory demand suggests, at the least, the court should be slow to reach the conclusion that the company is unable to pay its debts from the mere fact of non-payment of a debt which has never been demanded of it at all. And then the second relevant passage from this judgment appears on page 58. So after the passage I've taken your lordships to, the judge considers the Cornhill insurance case and the Taylor's industrial flooring case, which I've taken the court to. And then, beginning below letter E, having noted a feature of both the Cornhill insurance case and the Taylor's industrial flooring case is that the company knew what it was being asked to pay and did not or could not bona fide dispute that the amount it was being asked to pay was payable. He went on to note in the present case, the amount said to be demanded is an amount which was never communicated to the company, which the company could not have worked out for itself. And so he reached the conclusion on the facts of that case, that because there had been no proper demand for payment, inability to pay could not be inferred. The third relevant authority is the decision of Mr. Justice Morgan in the easy letting and leasing case, which is tab 7 of the authorities bundle. And the court will see from paragraph 4 on page 63 that there were two issues in this case. The first concerned what the court should do in respect of a substantial dispute of fact. And then for present purposes, the second issue was of relevance. What attitude should the court take where the company owes a sum of money which it cannot properly dispute, but it has failed to pay, having had an opportunity to pay? This issue is addressed in the judgment from paragraph 8 onwards, which appears on page 65, under the heading the second question. So having identified the relevant statutory provisions in paragraph 8, and then considered the authorities which I've taken the court to in paragraphs 9 and 10, the judge then at paragraph 11 drew the relevant principles together, and rather than reading out that very long passage, I just invite the court to read paragraph 11 in its entirety. So the key point is that the court cannot infer insolvency from the non-payment of an undisputed debt unless the company was first given an opportunity to pay. An axiomatic proposition, my respectful submissions. The fourth and final authority I want to briefly look at is the recent decision of Mr. Justice Miles in the reaccompanied decision which appears behind tab 13 of the authorities bundle. This was an appeal against the dismissal of a petition at a preliminary hearing on the basis, as in the present case, that the petitioner had failed to satisfy the coronavirus test. And I will return to the decision in due course for what the learned judge had to say about the coronavirus test. But for present purposes, the relevant passage is paragraph 54 on page 179. And it's the second sentence onwards. To determine whether the ground in section 1231E is made out, the court considers, at the time of the hearing to wind up, whether the company is unable to pay its debts. The test is expressed in the present tense. The non-payment of a historical debt may or may not constitute good evidence that the company is unable to pay its debts as at the time of the hearing. That then is the landscape which existed before the interposition of the restrictions in the 2020 legislation. And I should note parenthetically, of course, that before that act was passed, a company which was served with a winding up petition which disputed the debt on substantial grounds would need to apply to the court for an injunction restraining advertisement if it wanted to avoid the consequences of advertisement, which can be terminal, in essence the bank account being frozen, inability to trade on, adverse publicity, and all the other well-known consequences of the advertisement of a winding up petition against a solvent company. The Corporate Insolvency and Governance Act 2020 was enacted on the 25th of June of 2020, and Schedule 10 of that Act placed restrictions on the court's ability to make winding up orders against companies suffering from temporary cash flow insolvency as a result of the coronavirus pandemic. And in paragraphs 30 and 31 of his recent judgment in the Specialty Steel UK case, Chief ICC Judge Briggs has helpfully set out the relevant passages of explanatory notes which set out the purpose for which the legislation was enacted. That is behind tab 12 of the authorities bundle on page 147. And so firstly, at paragraph 30, the judge quotes from paragraph 3 of the explanatory note, which explains the mischief and objective of the new measures, which were that due to the COVID-19 pandemic, many otherwise economically viable businesses are experiencing significant trading difficulties. In addition, the government enforced social distancing measures and reduced resources are making it hard for many businesses to continue to trade and meet their legal duties. This act is aimed at ensuring businesses can maximise their chances of survival. And then paragraphs 22, 24 and 25 are also relevant. Paragraph 22 stated that the government is legislating to temporarily prevent winding up proceedings being taken on the basis of statutory demands and to temporarily stop winding up proceedings where COVID-19 has had a financial effect on the company, which has caused the grounds for the proceedings. And then so 24 notes, the Act also creates an additional condition that must be satisfied before a creditor can obtain a winding up order against a company on the grounds that it's unable to pay its debts. During the restriction period, any creditor asking the court to make a winding up order on those grounds must first demonstrate to the court that the company's inability to pay its debts was not caused by the coronavirus pandemic. And then paragraph 25 notes that the measure will apply to any winding up petition presented in the period from the 27th of April 2020 to the 30th of September 2020. That relevant period was in fact extended on 4 occasions and eventually expired on the 30th of September 2021. Then with effect from the 1st of October 2021, the old Schedule 10, which I'll take the court to in a moment, was replaced in its entirety with a new Schedule 10, which contained more limited restrictions on winding up petitions. In short, there was a minimum threshold debt of £10,000. There was a need to give the company 21 days to put forward proposals for repayment first, and the petition debt had to be for a liquidated sum, which was payable immediately. It is no longer possible during that period to petition for unliquidated debts or for debts that would fall due in the future.
And where were we in the scheme of things in this case? It must have been a first extension, well, the first period and then a first extension of that period.
Yes, and I'll show you in a moment. The authority we're giving you in the bundle is the schedule as it appeared at the time when the petition was presented.
Right.
Because the petition, I think from recollection, was after the 30th of September 2020, but there had been an extension extending that period to, I think, December. But I can show you the exact dates in a moment.
Yes.
For reference to the authorities. But just to complete the picture for the court's benefit, the new Schedule 10 came to an end on the 31st of March of this year.
Okay.
So that as from the 1st of April, there are no longer any coronavirus restrictions. We are back to the old regime of it being necessary to apply for an injunction to restrain presentation or advertisement. There being no impediment now on a company's ability to petition on the grounds of inability to pay debts.
So on any view, the issues raised in this case are of very, might I say, little interest, but not, I don't mean that. It's just that they apply in a very narrow band of time.
Yes, and it may be in practice that there are perishingly few, if any, petitions left where the court has to hear a preliminary hearing, but it's impossible to say. There may be some legacy cases where they're still working their way through the system for one reason or another. Schedule 10, as it was enforced at the time of presentation of the petition, is behind tab 2 of the authorities bundle. And to answer my Lady Justice Asplin's point, the version we have is after the first extension, and the relevant act extending is the slightly overly wordy Corporate Insolvency and Governance Act 2020, brackets coronavirus, brackets extension of the relevant period, close brackets regulations 2020. And that extended the initial relevant period from ending on the 30th of September to ending on the 31st of December of 2020. And of course, in our case, the petition was presented on the 5th of October 2020, so 5 days after this first extension. Paragraph 1 of Schedule 10 introduced a blanket restriction on presenting winding up petitions based on statutory demands served during the relevant period. And then, importantly for present purposes, if one turns to page 6, paragraph 2 then imposed a restriction on standing to present a winding up petition. And for petitions based on section 1231E, the relevant provisions are subparagraphs 3 and 4. So by subparagraph 3, a creditor was unable during the relevant period to present a petition on the ground in section 1231E, or indeed 1232, unless the condition subparagraph 4 was met, and that condition was that the creditor has a reasonable grounds for believing that either coronavirus has not had a financial effect on the company, or that the relevant ground would apply even if coronavirus had not had a financial effect on the company. And as I say, that was a threshold restriction on standing, because there needs to be grounds for reasonable belief in order to properly present a petition. And that is then mirrored in paragraph 5, which imposes restrictions on the court's powers to make a winding up order, which is the corollary of paragraph 2. Paragraph 5.1 sets out the circumstances in which that paragraph applies. And so firstly, it applies where a creditor has presented a petition in the relevant period. That's 1A. B, the company is deemed unable to pay its debts on a ground specified in 1231. That is to say, one of the grounds for making winding up order is made out. And then C, it appears to the court that coronavirus had a financial effect on the company before the presentation of the petition, which in the present case is common ground, because obviously in a case where coronavirus has had no financial effect on the company whatsoever, there's no need to go on to consider the question of whether or not it would have been unable to pay its debts but for the impact of the pandemic. Subparagraphs 2 and 3 then set out the restrictions which apply where the 3 criteria in 5.1 are met. For present purposes, we're concerned with subparagraph 3, which provides the court may wind the company up under section 1221F, so on the grounds the company is unable to pay its debts, on the grounds specified in section 1231E, that is to say, unable to pay its debts as they fall due, only if the court is satisfied that the ground would apply even if coronavirus had not had a financial effect on the company. In other words, the court must be satisfied that the company would be unable to pay its debts as they fall due, even if coronavirus had not had a financial effect on it. And it is common ground that the burden is on the petitioner to demonstrate that that is the case. And an authority for that proposition can be found in paragraph 45 of the judgment of ICC Judge Barber in the rear company case, which appears behind tab 9 of the authorities bundle, and that has then been followed in the 4 decisions at tabs 10 through 13, all of which have been examples of first instance judges, or in one case appellate judge, considering the coronavirus test. And I took your ladyships and lordship a moment ago to Mr Justice Marl's decision in the rear company case insofar as it concerned the section 123 test, but he also provided some helpful guidance on the paragraph 5.3 test in the 2020 Act in paragraphs 46 to 56 of his judgment, and that starts on page 178 of the authorities bundle behind tab 13. And I'll just draw out what I say are the key passages. So in paragraph 47, in the third sentence, he said that paragraph 5.3 requires the court to carry out a counterfactual exercise and ask whether the grounds in section 1231E or 2 would apply even if coronavirus had not had a financial effect on the company. That is naturally to be read as a reference to the same financial effect as is referred to in 5.1. That's to say, any such effect before presentation of the petition. And then in 48, he said that the counterfactual question has to be considered as at the time the court is considering the application of Schedule 10. And this includes considering the financial effect of coronavirus on the company up to that date, or at least up to the date of the presentation of a winding up petition. Now, the reason he says that is that in the court below, you have the judgment of the court below behind tab 11, there had been an argument between the parties as to what the date was that applied. Neither of them argued it was as late as the date of presentation of the petition. The judge below, ICC Judge Barber again considered that there was a good grounds for saying that it was the date of the petition, but nothing turned on it particularly. But Mr Justice Miles in the appeal court confirmed in my submissions rightly that clearly one is approaching the Schedule 10 exercise at the date the matter's before the court. That's the date to assess whether the company would have been unable to pay its debts even if coronavirus had no effect, because that's the date in which the question arises under the statute. And then in paragraph 50, Mr Justice Miles went on to say that the statutory counterfactual exercise requires the court to ask what would have happened absent the coronavirus, and in particular whether the grounds in section 1231E or 2 would have been made out. And then in 52 and 53, and this I say is important for reasons to come on to, but particularly my Lord Justice Birss, his concerns about my learned friend's assumptions. He went on to say the statute does not require the court to assume that the winding up proceedings were commenced earlier than they were. Instead, it requires the court to ask in relation to the actual winding up proceedings whether the ground in section 123 would have been made out in the absence of coronavirus. And finally, in paragraph 54, he rejected an argument that suggested the court puts on blinkers and only looks at the events giving rise to the debt claimed in the petition and the immediate non-payment of the debt, and went on to say, as I've already shown the court, that that issue is looked at as at the date of the hearing. That then is paragraph 5. The other relevant provision of the 2020 Act is paragraph 19 of Schedule 10, which appears on page 23. And my learned friend took the court to it very briefly, but I do want to just dwell on it slightly, because in my submissions it is informative of the exercise that has to be performed at the preliminary hearing. So as I've already indicated, prior to the enactment of these regulations, ordinarily what happens is that following presentation of a winding up petition, it is listed in the winding up list in the normal way, and then under Rule 7.10 of the Insolvency England and Wales Rules 2016, a petitioner must give notice of the petition by advertising it in the Gazette. That must be done not less than 7 business days after service of the petition, and not less than 7 business days before the hearing. And the reason for that effective 10-day window between service and advertisement is to give the company an opportunity to apply to restrain advertisement of the petition. Now, what paragraph 19.2 did was to introduce restrictions on the ability of a petitioner to advertise a petition. And so it provided that, in essence, petitions could not be advertised until, and this is the critical passage, such time as the court has made a determination in relation to the question of whether it is likely that the court will be able to make an order under section 1221F. That is to say, a winding up order on the grounds the company is unable to pay its debts. That is the determination which the court below was required to make. And as Judge Cadwallader noted in paragraph 28 of his judgment, this provision does not refer explicitly, let alone exclusively, to the coronavirus test. It simply says the court must make a determination of whether it's likely it will be able to make a winding up order. Now, Schedule 10 was supplemented by a practice direction, which appears behind tab 3. This was published by the Chancellor on the 3rd of July 2020.
Sorry, before you go on, so what do you say about a lack of reference to the coronavirus test in 19.2?
Well, what I say is that, therefore, at the preliminary hearing, the question which the court must ask itself is it likely I'll be able to make a winding up order? And before one gets to the question of the coronavirus test, one first has to be satisfied that the 3 conditions in 5.1 are met, one of which is that the company is unable to pay its debts as they fall due. I will come back and address this fully in due course, my lady.
Okay, I'm sorry, so you're going on to the practice direction.
This is built into my submission that, therefore, at a preliminary hearing, the court must consider a question of substantial dispute first. And my alternative submission that even if it's not necessary, it nevertheless should have done in this case, because it leads us to the mental gymnastics which the judge is painfully aware of. So the practice direction, my learned friend did briefly take you through it earlier. In paragraph 2, on page 30, provides that paragraphs 3 to 8 apply to petitions presented during the relevant period against the company under Section 1221F on any of the grounds specified in Section 123, and it comes into force on the day that the 2020 Act comes into force. Paragraph 3 then provides that a petition will not be accepted for filing unless it contains the statement required by Rule 7.5, as amended by paragraph 19.3. That is to say, the statement that there are reasonable grounds for believing that either coronavirus has not had an effect or that the company would have been insolvent in any event. And then my learned friend took you to paragraph 4.1 and 4.2. So 4.1 provides that assuming a petition has been accepted for filing, then it's listed for a non-attendance pre-trial review with a time estimate of 15 minutes on the first available date after 28 days. Now that 28 days is no coincidence for reasons I'll come on to show in a moment. And 4.2 then says the purpose of the non-attendance pre-trial review is to enable the court to give directions for a preliminary hearing in order for the court to determine whether it is likely it will be able to make an order under Section 1221F. Now that is taken straight from paragraph 19.2. But the additional wording that doesn't appear in the statute, but is in the practice direction, is having regard to the coronavirus test. And the court's already seen what the coronavirus test means in this context, but just for a reminder, that's defined in paragraph 1.1, subparagraph 3b. In this context is simply whether the condition in paragraph 5.3 is met. But again, I make the point, what this does not say is having regard exclusively to the coronavirus test, which essentially is the thrust of my learned friend's position, and with respect to the courts below, the judges below, essentially took the position that at the preliminary hearing, all the court considers is the coronavirus test, and for reasons I'll develop in my submissions, that's wrong as a matter of approach. Just staying with the practice direction, just finishing the relevant provisions, paragraph 5.1 provides that until the court has concluded it's likely it will be able to make an order having regard to the coronavirus test, or further order in the meantime, the petition shall remain private. That, of course, reflects the provisions of paragraph 19 of Schedule 10. And then in paragraph 6, there is provision for the filing and service of evidence by the petitioner and the company in advance of the non-attendance pre-trial review. And the purpose of that clearly is so that the court, considering whether to list the matter for a preliminary hearing, is aware both what the parties say, respectively, in respect of the coronavirus test, but also if there are any other issues that need to be determined at the preliminary hearing. And then paragraph 7 provides that at the non-attendance pre-trial review, there's essentially two options for the judge. If the company does not oppose the petition, and the court is satisfied on the papers that it's likely a winding up order can be made having regard to the test, then the petition is simply listed in the winding up list, at which point the restrictions on advertisement fall away and the matter then proceeds as it would have done but for coronavirus. But if the court is not satisfied of those two things, so either the company opposes the petition or the court can't be satisfied of the test on the paper, then it lists the preliminary hearing and gives such other directions as it thinks appropriate. And then allied to that, paragraph 8 says that at the preliminary hearing, if the court is not satisfied it's likely it will be able to make a winding up order having regard to the coronavirus test, it dismisses the petition. Otherwise, as again, it lists it in the usual way, restrictions on advertisement fall away, and then the matter proceeds in the winding up list as it would have done but for the coronavirus test. Now, in the present case, the petition, as I say, was presented on the 5th of October 2020. It was listed for preliminary hearing on the 9th of February of 2021, and an issue arose at the first hearing between my learned friend and I as to whether the court should or could consider the company's claim that the petition debt was disputed on substantial grounds and dismiss on that basis. Now, this is an issue which I touched upon in over to comments in my own decision sitting as a deputy judge, and I appreciate it's somewhat unseemly to be inviting the court to look at passages of my own judgment, but nevertheless, it's hopefully instructive or illustrative because it supports the submissions I make today before the court. So that authority is...
Well, it presumably is consistent with the submission you're about to make.
It is indeed.
Yes. Where is it?
But that, of course, that's not always the case that one finds oneself arguing the same point as one concluded as a judge, but happily in this case it's ad idem. And it's tab 10 of the authorities bundle, page 107. But the starting passage I want to take the court to is on page 112. So in this case, the company which had had a winding up petition served upon it sought either the dismissal of the petition or an order restraining the petitioner from advertising it. And counsel for the petitioner argued that this was a premature and pointless application because as a result of the restrictions there was no ability to advertise the petition until the coronavirus test had been determined in any event. And as I observed in paragraph 33, and it's a point I've already made to this court, before the enactment of the coronavirus legislation, it was of course necessary for a company served with a winding up petition which disputed the petition to apply for an injunction restraining advertisement in order to avoid those consequences I already spelled out. And then in 34, I noted that the introduction of paragraph 19.2 had removed the immediate need for a company served with a winding up petition to seek an injunction to restrain the advertisement of the petition. And then I went on to say, as the court will necessarily have to consider any alleged dispute of the petition debt at the preliminary hearing, in order to determine whether it's likely to be able to make an order under section 1221F, a company may simply wait until that hearing to determine the issue. Now, the reason why I said that, and the reason why in my submissions today I say that's the right approach, is just remind the court of the passages we've seen. Under section 123, the court can only make a winding up order under section 1221F if one of the grounds in section 123 is made out. And of course, under paragraph 5.1 of Schedule 10, the coronavirus test only arises if one of the grounds specified in section 1231 for making a winding up order is made out. And so if the question which the court has to consider is that which is spelled out in 19.3, which is simply, is it likely the court will be able to make a winding up order, with no reference explicitly or exclusively to the coronavirus test, then in my submissions what the court has to do is start with paragraph 5.1, ask itself, is this a petition which was presented in the relevant period? If yes, are the grounds for making a winding up order otherwise made out? If yes, has coronavirus had a financial effect on the company? If yes, then it's the 5.3 question. And the answer to my learned friend's concern, which is that this front loads everything and the court's addressing the issue which it would otherwise have to deal with at the final hearing, is that actually, in fact, what the court is doing is addressing the issue it would otherwise have to consider on the company's application to restrain the presentation of the petition. The only reason why the company is not making an application to restrain is because Parliament has removed the ability of the petitioner to advertise. And to finish the thought, what I went on to say in paragraph 35 is that there was no reason why this should prevent a company from applying at an early stage for the strikeout and or summary dismissal of a petition if it wishes to do so. So you can wait for the preliminary hearing, but if that's going to take 6 to 8 weeks, and in the meantime there's potential risks, and I identified some in paragraph 5, where the presentation of the petition is an event of default, for example, for funding purposes, then the company may well want to get before the court at the earliest opportunity to get this petition knocked on its head. Now, as set out in paragraphs 37 to 40 of his judgment, Judge Cadwallader reached a different conclusion. And I would like to just look in some detail at his judgment, because with the greatest respect to the learned judge, in my respectful submissions, he did fall into error in his approach, and that then permeates the difficulties my learned friend finds on this appeal. So the relevant passages in the core bundle on page 60 behind tab 7, and it starts in paragraph 37. of the judgment. And what the judge says is, having, in the third paragraph, having identified the paragraph 19.2 provision, so SEGA requires the court to make a determination whether it's likely the court will be able to make an order under section 1221F. He then says that the court has to read additional words into the statute. The court has to add the words, given the restrictions on winding up petitions for which Schedule 10 provides. That then leads him in paragraph 38 to say that what the court must do at the preliminary hearing is just simply assume that the ground in section 123 is made out, rather than determining whether it's likely to apply or not, and then ask, well, assuming that the ground is made out, and the company therefore is presently indebted to the petitioner, would it have been so indebted if coronavirus had not had a financial effect upon it? And in effect, therefore, there is a counterfactual exercise based upon a hypothetical, or arguably a counterfactual based on a counterfactual, depending on the strength of the dispute of the substantial debt. He did go on, however, to say that the reason that didn't cause concern is because the court always has the ability, as a matter of case management, nevertheless, to consider the substantive dispute question at the hearing itself. And he goes on in paragraph 39 to say that the reason why this approach is right is because it's unlikely Parliament would have intended to raise the threshold for petitions on grounds unrelated to coronavirus. And with the greatest respect to the learned judge, it's unclear to me precisely what he had in mind when he was suggesting that to approach the matter on the basis the court considers whether there's a disputed debt first somehow raises the threshold for petitions. Because clearly, in considering whether there's a substantial dispute, the court simply applies the test as it always has done, which is ask whether the company has a real prospect of demonstrating that debt's not owed. And if it does, then the petition is treated as an abuse of process. Therefore, the petitioner is not a creditor for the purposes of the Insolvency Act standing petition, and therefore the matter has to go to a Part 7 claim. And then in paragraph 40, he concludes, having considered the judgment which I showed you a moment ago, that the court would not necessarily have to consider any alleged dispute with the petition debt at the preliminary hearing. And as I've indicated, my primary submission is that the judge's approach in this respect was wrong, and I say that for two reasons. And the first is that, as is clear from paragraph 37 of his judgment, his interpretation of paragraph 19.2 requires the court to read additional words into the statute, which don't appear in circumstances where there's absolutely no need to add any additional words to the statute in order for it to make sense. And so I say this was an impermissible exercise in statutory construction on the judge's part. If one simply reads what the statute says, what is the question the court must determine? It is whether or not it's likely to be able to make a winding up order. And a critical factor in that is whether the grounds for making a winding up order are made out. And insofar as there could be said to be any inconsistency between that and the practice direction, which adds the words having regard to the coronavirus test, well, that potential mischief is resolved by treating the words having regard to as meaning having regard to, but not exclusively to, the coronavirus test. Because, of course, that is one of the issues that may arise for consideration at preliminary hearing. And in many cases, it may be that there is no substantial dispute, and that the company is not arguing, in fact, that this is a petition they would have been able to restrain, but rather they are putting their lot entirely on the basis that they were a solvent company up to and including the start of the pandemic, but are suffering from temporary cash flow illiquidity because of the effects of lockdown, which is the precise reason why Parliament enacted the 2020 Act in the first place, to provide protection to otherwise viable trading businesses that were suffering as a result of the pandemic. And the second reason why I suggest, with respect, that the learned judge below was wrong in his approach is that he appears to have based his decision, as I indicated in paragraph 39 of his judgment, on the assumption that somehow, if the court looks at the question of substantial dispute at the preliminary hearing, the threshold for petitions is raised, even in cases where coronavirus is irrelevant. But as I hope I've demonstrated, that's clearly not the case, because it would always be possible to seek to restrain on an early stage rather than have to wait to the final hearing to determine that issue. And I'd simply note en passant that this appears to have caused Lord Justice Lewison concern when considering the application for permission to appeal. His reasons are, it's page 29 of the core bundle behind tab 4. The first of his reasons for granting permission was he said that it seems artificial to ignore the underlying fact that the debt is disputed even at the interim stage. And secondly, he says he's doubtful whether the judge's interpretation of 38 is correct. That is where the judge says one has to just assume that the debt is undisputed, and then, as I've described it, it's the counterfactual built upon a hypothetical or another counterfactual. Now, if the court accepts my submissions on this basis, it leads then to my submission that the petition should have been dismissed for substantial grounds, which I'll come on to. But it also addresses my Lord Justice Birss's concerns about the assumptions on which my learned friend's case is built, because if in fact the court starts with dealing with the question of substantial dispute, there's no factual assumption made. The court deals that issue first. If the court concludes there is no substantial dispute, there's no longer an assumption at the coronavirus test stage, because there is then simply an undisputed debt, or more accurately, a debt which the court has concluded there's no substantial dispute in respect of, and then one is dealing with the coronavirus test squarely on the footing of, could the company have paid this undisputed debt but for the effect of coronavirus? Now, even if the court concludes that I'm wrong, and in fact actually at the preliminary hearing it's not necessary to consider the question of substantial dispute, of course the learned judge below accepted that that was something the court could have considered as a case management decision. Now, in my respectful submissions, the district judge's decision not to address that issue at the first hearing was perverse, because, as I've already said, the companies made it clear from the outset that the petition was disputed on substantial grounds. The petitioners were given ample notice that the issue would be ventilated at the preliminary hearing, and in fact they were in a position to, and did make submissions on the question of whether or not this debt was disputed on substantial grounds at that hearing. And I'm just briefly, by reference to the evidence before the courts below, make that point good. So the petition, as I've indicated, presented on the 5th of October 2020, listed for non-attendance pre-trial review on the 9th of November. On the 29th of October, in anticipation of the non-attendance pre-trial review, the company filed Mr. Valentine's first witness statement. That appears in the supplementary bundle behind tab 16. And I didn't take your lordships there, but just for your pen, paragraphs 17 to 25 on pages 88 to 90 set out the grounds on which it was said that the petition debt is disputed, and in paragraph 40 invited the court to dismiss the petition on that ground. Then on the 27th of November, District Judge Obadiah listed the petition for a preliminary hearing with a time estimate of 2 hours, and ordered the parties to file any further evidence by the 15th of December, and her orders tab 3 of the supplemental bundle. On the 14th of December 2020, the company filed Mr. Valentine's second witness statement, which is tab 20 of the supplemental bundle, and in paragraphs 16 to 17 on page 130, he reiterated that the petition debt was disputed on substantial grounds, and that the company sought dismissal on that basis. And in paragraph 21, he repeated what those grounds were. And then on the following day, the 15th of December, the petitioners filed the witness statement of Annette Doran, which is tab 21 of the supplemental bundle. And that witness statement was directed entirely to whether or not there was in fact a petition, a debt in existence. It did not in any way correct the question of coronavirus test. And as I've indicated, my learned friend, in both his written and oral argument, set out before the court at first instance arguments as to why he said that the debt was not disputed on substantial grounds. And in short, the district judge, in his judgment, concluded that although he heard argument, he didn't feel it was the right forum to determine the issue on that footing when he could deal with it on the coronavirus test basis. And in my respectful submissions, that was an error, because his approach would lead to additional cost and expense of needing a further hearing when he could have grasped the nettle when the matters before him. And finally, in paragraph 10 of his supplemental skeleton argument for the appeal below, and this is the document which was handed up at the start of the hearing, It's page 51B of the supplemental bundle. My learned friend conceded that if the company had made a formal application to dismiss the petition on the basis of substantial dispute, then it would make logical sense to deal with that application at the preliminary hearing before coming onto the coronavirus test. And I say it would be a triumph of form over substance if the company was obligated to incur the cost of issuing a formal application just in order for the court to be prepared to deal with this matter at the preliminary hearing, when the evidence and the skeleton arguments leading up to the hearing had made it clear that this was a live issue that was going to be taken by the parties. And I've said the consequence of refusing to have the matter dealt with at the preliminary hearing is that were the court to conclude the coronavirus test was met, the company would then immediately need to issue an application for an injunction to restrain advertisement, argue the toss again on the question of whether or not there was a substantial dispute. And in my submissions, that's an approach which is not justified by reference to the overriding objective. So for those reasons, I say, in fact, the court below should, or if the court's not with me, at least could and therefore should, have addressed the question of the substantial depth first. And I can then deal with this issue very, very swiftly. I've set out in my skeleton the argument in full. But as the learned judge at first instance noted, the facts of this case are very unusual. It's common ground that the company is responsible for collecting rent on the petitioner's behalf and accounting for the petitions in respect thereof. 7 years between 2013 and 2020, the company paid the rent into the Barclays account without demur, and in fact it provided monthly statements to the petitioners setting out those payments. And that is set out in paragraph 10 of Mr. Valentine's first witness statement on page 87 of the supplemental bundle behind tab 16.
And is that agreed, that those monthly payments were set out?
There was no dispute of the evidence that there were statements provided to the petitioners on a monthly basis, which
Yes,
set out the
I
payments.
wasn't sure that it was, maybe that I've just misremembered it, that there wasn't an acceptance that the monthly sums were identified each time. But I may have misremembered that.
My recollection, I can address the point by reference to the evidence, is if one looks at page 87 of the supplemental bundle, the statement of fact put forward by Mr. Valentine in paragraph 10 is that every client for whom the company managed property is sent a monthly statement which sets out the amount of rent collected and payments issued to the client. And the response to that evidence is Mr. Doran's witness statement behind tab 18. And that statement does not address that issue. It addresses the issue of whether instructions were given to pay the Barclays account, but not the point that monthly statements would have been sent. And there is also a further witness statement from Annette Doran, which is behind tab 21 of the hearing bundle. And again, that is directed to the assertions that no instruction was given, and perhaps I think the closest is paragraph 10 on page 135. And in fact, actually, this answers my lady's question. She says, we employed them as professionals and we trusted them. When we received the statement saying money had been paid to us, we believed them and assumed payments had been made to the Clydesdale account utilised by us. So in fact, it goes beyond, not only is there no dispute, in fact, it's accepted the statements were sent. So they were notified payments were being made, but at no point before 2020 did they say they've not been received. So it was March,
That's what it says, yes.
March 2020, 7 years after the payments had first been made into the Barclays account, that the petitioner said for the first time that that account has nothing to do with them, and therefore the company owes them 7 years of accrued unpaid rent. And this raises three obvious questions which in my respectful submissions demonstrate why this matter should, if at all, have been brought by a Part 7 claim and not a winding up petition. The first and most obvious question is, why did the company start paying rent into the Barclays account? So the petitioner's evidence in their witness statement is a denial that they instructed the company to make the payments. But the company's position is that it's inconceivable that it would have started paying money into a bank account without instructions to the petitioners. And because the petitioners have taken so long to raise the issue, there are obvious evidential difficulties for the company because it doesn't have the records going back beyond the 7-year period when an instruction would have been given. But what the court did have below was Mr. Valentine's evidence in his witness statement on page 87 of the supplemental bundle, paragraph 9. This is behind tab 16. In which he says that it's the company's standard practice to ensure that any bank account changes are verbally verified with the client, and this has been the case for some time. So, at the very least, there is clearly a genuine tribal issue as to whether or not the petitioners instructed the company to pay monies into the Barclays account. The second obvious question is, whose bank account is the Barclays account, and what's their relationship to the petitioners?
Or the company. Or the company.
Or the company, indeed. I accept that. We simply don't know. And the difficulty is that Barclays have refused to divulge the identity of the account holder. And you see that in the evidence of paragraph 16 of Mr. Valentine's statement. But of course, if these were Part 7 proceedings, that wouldn't be a problem, because the court would have the power to make orders compelling the disclosure from Barclays. Again, another indicia of why, if at all, this should be brought in ordinary commercial proceedings, not on a winding up petition. And then the third obvious question is, why did the petitioners not raise any complaint about the alleged non-receipt of rent for 7 years? And that's relevant in two ways, because first, it supports the inference that the petitioners did in fact instruct the company to make the payments, because having received the statements every month, and we're talking about large sums of money supposedly accruing, it's surprising, to say the least, that they would at no point in 7 years have demurred about those payments. But secondly, it may well entitle the company to raise a defence of estoppel by convention or acquiescence. Again, in circumstances where they have been making payments into an account and accounting to those payments to the petitioners in the sense of, we have made this payment on your behalf, and at no point have they come back saying, actually, in fact, we haven't received those. What's going on? There's an additional point, which is a minor point, but the petitioners have never actually provided proper particulars of the quantum of their claim. And again, just for the court's pens, in paragraph 12 of his second witness statement, Mr. Willen, this is page 68 of the supplemental bundle, said that a full spreadsheet would be submitted before the hearing, but it was never actually produced. So, in the circumstances, in my submissions, and this is really the elephant in the room, it is clear that this is a disputed debt petition. And the presentation of it was an abuse of process, and it should have been dismissed by the court at the preliminary hearing on that basis. And that is my alternative ground for upholding the decision below, which, as I said at the very start of my submissions, was simply to dismiss this petition. And in the event that this court is against me on the coronavirus test, which is the reasons I come to now, I say the judge is right on, and is against me in terms of the courts below should have dealt with this issue themselves, I would invite this court, in the exercise of its case management powers, to dismiss this petition rather than requiring the company to have to go to the expense of applying for an immediate injunction, which this court is as well placed as any court below to see, would have to be granted and the petition struck out, because this is clearly a disputed debt petition. And I think my learned friend tacitly accepted that when initially, under questioning this morning, he accepted that there was a dispute, although he did row back from that, and I accept that his position is there's no substance to the dispute, but I've demonstrated that clearly there is. I turn now, and I'm mindful of the time, and I'm mindful of the fact that, well into my submissions, I haven't yet actually addressed the issue under appeal.
Sure, you're going to do that now.
I am, and I'm going to do it very concisely and swiftly, because I've already, I hope, done the groundwork by taking your lordship and ladyships through the relevant law. Just to remind the court of the provisions of paragraph 5. I know we've looked at them in some detail, but it's useful just to go back there to ground my submissions. So paragraph 5 of the 2020 Act, sorry, more accurately, paragraph 5 of Schedule 10 to the 2020 Act is behind tab 2, page 9 in the authorities bundle. And starting with subparagraph 1, it's common ground that the condition in 1A was satisfied. This was a petition presented in the relevant period. I accept that if the court gets to the coronavirus test, then we are proceeding on the assumption that the court has been satisfied that the ground in B is made out. In the sense that my primary submission as you have is this is a debt which is disputed on substantial grounds and you should dismiss and strike out the petition on that basis.
Say that again slowly, Mr. Parsfield.
Forgive me, my lady. My primary submission is that the debt is disputed on substantial grounds.
Yep.
For that reason, we don't get to the coronavirus test.
Yes.
It follows if we're looking at the coronavirus test, it must be because the court has concluded that, in fact, the debt is not disputed on substantial grounds. So I accept that if we're looking at the application of paragraph 5.3, my learned friend must have jumped through the 3 hoops in 5.1. So it does involve a degree of counterfactual. I accept that it's no answer for me if we're looking at the coronavirus test to say, oh yes, but the debt is disputed. We paid on instructions and therefore we have paid the debt. I have to start with the premise I accept there's an underlying indebtedness. That doesn't mean, for reasons I'm going to come on to now, that the court ignores the reasons why that indebtedness accrued in the first place.
So the point you're making, Mr. Mansfield, is about the structure of paragraph 5.
I am.
Because you say it's in 2 parts, and one part in sub 1 has 3 bits to it, one of which is a positive conclusion that the company is deemed unable to pay its debts.
Yes.
And then you say it's only in that context that the coronavirus bit in sub 3 applies, and that's why when you say assumption, that's what you're talking about.
Precisely, my lord.
Yeah.
And then it was common ground below that condition C is met as well. So the burden was on the company to show coronavirus had a financial effect. We put in evidence to that effect. That was unchallenged. And it's, as I've said, common ground, therefore, that then one gets to 5.3, and it's for my learned friend to persuade the court that that condition is met. So it's for my learned friend to show that the company would have been unable to pay the 65,000 odd that on this hypothesis it owes to the petitioners, even if coronavirus had not had a financial effect upon it. Now actually, in fact, the appellants did not in the petition itself spell out why they had reasonable grounds for believing that the coronavirus test was met. And one can see that the petition is on page tab 13. Sorry, yes, tab 13 of the core bundle. And I suspect that this was simply as the new restrictions were bedding in and solicitors were getting used to how to present petitions in the new landscape. One can see that on page 84, under the amended practice form, letter J, there's a section to set out the grounds on which the winding up order is sought. And that's blank. And then under L, there's a section for setting out the grounds for either believing that coronavirus has not had a financial effect on the company, or that it would have had a financial effect in any event. And what then appears in the petition, in fact, is not the reasons for saying why the coronavirus test is met. It's the reasons why the petitioner says there's an indebtedness, which is, we've just discovered that there's all this rent owing. We sent a demand for payment on the 27th of August, and it's not been paid. And this was a point that was taken by the company initially in its evidence in response to the petition, in saying, well, it should be dismissed anyway on formal grounds that it doesn't contain the requisite statement of grounds for believing. But that was remedied by the petitioners when they applied to set aside the wrongful striking out the petition as a result of the error by the district judge who thought that it was being brought on the back of a statutory demand. Mr. Willen's witness statement in support of that then set out what they had to say on the coronavirus test, and that forms the basis of their submissions below, and that is on page 68 of the supplemental bundle. behind tab 14. And it's done in a slightly counterintuitive way by responding to what was said by the company in its evidence. But in paragraph 16, what is said is, the witness statement of Mark Valentine suggests that coronavirus has had a financial effect on the company. But 4B clearly allows for a petition if the relevant ground would apply even if coronavirus had not had a financial effect. It is quite simply the case that the sums owing stem from well before 2020 and relates to the non-payment of rents between 2014 and August 2020. Even if one were to remove the payments owing from March to August 2020, this would only remove circa 7,500 of the monies claimed. So that is it in its entirety. Ah, well, this debt all arose before the pandemic, therefore you wouldn't have been able to pay it even if you hadn't had the financial effect of the pandemic. And as I've already demonstrated by reference to the case law, there is not an irresistible inference or an irrebuttable presumption that simply because a company has failed to pay an undisputed debt, it must be insolvent. The court will not draw that inference if there is a substantial reason for the non-payment. And in this case, it's clear from the evidence that the company was able to make each rental payment as it fell due, but it put the money in the wrong bank account, in the honest but mistaken belief that by doing that it was discharging its debts as they fell due. And so on the unusual facts of this case, the courts below were right not to draw the inference sought. There was a ready explanation. As I say in paragraph 32 of my skeleton, what the appellants needed to show was that if they'd notified the company of their outstanding indebtedness at some point prior to the pandemic and made a demand for payment, the company would have been unable to pay. But they didn't adduce any evidence to suggest that this was the case, and of course the burden was on them. And they rested their case entirely on the proposition that because the debt fell due for payment before the pandemic, that demonstrated insolvency. And so the court below rightly held that they failed to satisfy the burden on them. Now, in his submissions before the court today, my learned friend has sought to develop an entirely new point which was not raised below, which is that in essence, the court should either treat the company as not having genuinely believed that it was paying the money into the right bank account, or the court should treat that belief as irrational so as to get to the same place. And the court should have said, well, no, you were paying the money into the wrong account and there's no evidence to suggest that there was a basis for that, therefore the company should be treated as insolvent or the development inference should arise. As I say, that's not a submission that he made below. No evidence was led in that respect. And of course, as the judge recorded in his judgment below, it was common ground. And this is paragraph 41 of the judgment. This is a critical part of the judgment. It was common ground below, and so there's no need to argue to the contrary. That the company genuinely believed it was paying money to the wrong account. It's just that for the purposes of the coronavirus test, the court had to assume that belief was erroneous or was mistaken. So the company wasn't in fact paying its debts as they fell due. Therefore, there was an indebtedness. Therefore, one looks at the coronavirus test. But why was the company not paying its debts as it fell due? Not because it couldn't, but because it was paying the money into the wrong bank account. And then as to whether the company can now pay its debt, well, it's irrelevant because as a matter of fact, one knows that the petitioner can't show that the company would have been insolvent but for the coronavirus pandemic, and therefore that's an end of the matter. The coronavirus test is not met. And that is why I say that the judges below were correct. I'm mindful of the time. I'm conscious I probably need to just say something about each of my learned friends' grounds, but you have my overarching submission that they're not really grounds as such, but they're directed to the one core ground. I could probably do it, I suspect, subject to the court's intervention in 10 to 15 minutes. I'm in the court's hands as to whether to do it now or if you prefer to rise, and I can address it briefly after the lunch interval.
Yes, Mr. Ayu, how long do you think you'll be?
If I reply, lady, I can probably do that in 10 to 15 minutes as well. So if the court were kind of willing to stay sitting, probably could be done by, well, before 1:30, I imagine.
Experience has taught us all, I think, that a short break sometimes leads to shorter submissions. So we'll rise at 1. So you've got 7 minutes until then.
Well, in that case, if I aim to maybe deal with ground 1 in those
Very
7 minutes. And this ground is that the judge was wrong to rely on the fact that the company believed it was making payments to the Barclays account on instructions. This is based on a fundamental misunderstanding of the judgment below. So the relevant passage, my learned friend has taken you to it, but just to remind the court, I appreciate it's been some time that I've been on my feet since he was speaking. It's paragraph 41 on page 61 of the core bundle. And I think my learned friend suggested that this could be divided into 3 parts, and I agree that there's essentially a section setting out the law, then a consideration of the relevant evidence in this case, and then a conclusion. So the judge starts by setting out what he describes as some prefaces to his conclusions. And these are propositions to law which I think are uncontroversial and all derived from the cases I've taken the court to already. So non-payment of a single undisputed debt may be sufficient to satisfy the court the company is unable to pay its debts as they fall due. However, normally it must be shown the company was notified of the amount of the debt and given an opportunity to pay. That is because it's a matter of inferring inability to pay from non-payment. So 3 uncontroversial propositions of law. He then records the fact that the petitioners did not appear to dispute that the company believed it was making payments to the Barclays account on instructions. And there was no evidence it was aware that it had any outstanding indebtedness to the petitioners until March 2020. That is to say, it's a proposition my learned friend sought to argue contrary to in his submissions today, but that was no part of the case below. And then what I say is that therefore the relevance of that is that by reference to the 3 propositions of law that the judge had set out before in paragraph 41, there was an explanation for why the company had failed to pay the petition debt, which did not support an inference of insolvency. The company believed that it was paying its debts as it fell due and wasn't aware of that until after the onset of the pandemic. Put it another way, the company was not notified of the amount of the debt and given an opportunity to pay at any time prior to March 2020. And then the judge states his ultimate conclusion, which is that the fact that the alleged debt had accrued prior to the pandemic was not evidence that the company was unable to pay its debts as they fell due. Or to put it another way, it did not support the inference, which was the sole basis of the appellant's case. In his first ground of appeal, my learned friend says that the judge should have assumed that the appellants did not instruct the company to pay rent into the Barclays account. But with respect, that's precisely what the judge did. He proceeded on the assumption that the company had not discharged the petition debt by paying monies into the Barclays account. And we know that because he refers to the alleged debt having accrued prior to the pandemic. But he accepted that the undisputed fact that the company believed that it was meeting its obligations by paying rent into the Barclays account undermined the inference that it was because of inability to pay. And that's clear from the final sentence, paragraph 42, in which the judge noted that if there was if the debts had not been paid, the natural inference was that it was a result of a mistake. And as my Lord Justice Birss put to my learned friend in the course of his submissions, contrary to my learned friend's submission in paragraph 17 of his skeleton, the fact the company believed that it was paying the money on instructions was not inconsistent with no instruction having been given. On the contrary, it was common ground that when we're dealing with the coronavirus test, one proceeds on the assumption there was no such instruction, so there was an indebtedness. But the company had a genuine but mistaken belief that there was, or at least the company genuinely mistakenly believed that by paying money into this account, it was discharging its debt, against the context of it having accounted for those payments in the sense of providing statements saying we have made payments, and there being no response from the petitioners to the effect of, but we have not received any payment from you. So I say that ground one, as put in my learned friend's written argument and as formulated in the grounds of appeal, doesn't get off the ground, insofar as he now attempts to say that the court should in fact have gone further and should have assumed not only that no instruction was given, but that in fact the company had no genuine belief that such instruction had been given. Well, firstly, that's a new point that wasn't taken below and is not open to him to take today. Even if it were not, there's no evidence on his side to support that inference, as against the clear evidence from the company in a witness statement supported by statement of truth, to the effect that the company's usual procedure is it only changes accounts on instructions, and there's no reason to think that it would have done otherwise in this case. And so for those reasons, I say that whichever version of his ground one the court considers, it should be rejected. I'm mindful of the time. If I rest there, I can deal with the other four grounds in probably about 10 minutes at 2 o'clock.
Very good, thank you very much indeed. We'll rise and we'll come back into court at 2 o'clock.